Welcome to Tax Sale Insiders, the latest from Tax Sale Resources, bringing you information about tax sales from experts in the industry. We interviewed William Hereford, partner at Burr & Forman, based in Birmingham, Alabama. Will was pushed into tax lien law at the firm in the late 90s, figuring out what to do with those unredeemed lien portfolios, and he hasn't looked back since. In this interview, Will explains the two lien sale systems in Alabama and gives us an update to the latest Alabama Supreme Court ruling, which is rocking the tax lien world in his great state. So sit back and relax for another episode of Tax Sale Insiders, powered by Tax Sale Resources.
Hi, everybody. Welcome to this episode of Tax Sale Insiders. I'm Brian Seidensticker, CEO of Tax Sale Resources. And with us today, I managed to snag Will Hereford. He's an attorney with Burr & Forman out of Alabama. Welcome, Will.
Thank you, Brian. I'm glad to be here today.
Yeah, thanks for joining us. I guess there's a lot to talk about in Alabama from a system that kind of changed. It was the same way forever, and then now there's kind of two systems. So I'll dive into all that stuff here shortly. But I guess to begin with, give us a little bit of history on how you landed in the tax law industry. And I guess what I mean by that is most folks don't really aspire to become tax sale investors or tax sale attorneys or anything related to tax sales. So I'm always curious how people landed in this space.
Well, I've never asked other tax sale lawyers how they stumbled in, so you must have. And that is kind of the situation for me. You're right. I graduated from law school in the late 80s and never planned to be a tax sale lawyer. Of course, I don't think there was a tax sale lawyer in the late 80s. But I went to work with Burr & Forman here in Birmingham, and my practice had been in the 90s, a commercial practice, litigation practice, bankruptcy, creditors' rights practice, a lot of consumer litigation. And I think it was 1999, one of my partners came to me and another one of our partners and said, I've got this portfolio of tax liens purchased by this company out of New Jersey, and no one knows what to do with it. So you two go figure it out. And we did, and we, studied the law, and it was confusing as all get out. Really, I mean, Alabama statute, you try to read through it, is very challenging. But we got to figure it out enough to write a memo to the client, explain to them the situation and what their options were, and help them start working through some of the tax lien or tax certificates they had purchased in Alabama. And they were probably one of the first big ones. As I think I think this industry sort of got kicked up in the early mid 90s, and it hit Alabama probably like 96 or 97, but nobody knew it hit until probably 79 or 80. I'm sorry, I keep using the wrong dates. It hit in the 1990s, I think, and then by like 1999 is when people started realizing, it's here, and no one really knew what to do. I think people thought you come down and buy these liens in Alabama, they all redeem, it takes care of themselves, and then they end up with these portfolios where they hadn't redeemed and they didn't know what to do, and that's how it came to me. And that was like 1999, 2000. We sort of figured it out, and after that, I have a brother-in-law. Well, all my brother-in-laws, I have three brother-in-laws. They're all lawyers in Birmingham. One of them had a case where they helped some company deal that had bought a property for taxes and had some issues. And after handling it, my brother-in-law says, hey, I think you do this. You've done it. You know something about it. This company needs more full-time help. We're not really that firm. Would you help? And I was like, yeah, I can handle it. So now I had two clients. And then I went out to an NTLA meeting in Phoenix and picked up another one. And then all of a sudden, it's like dominating my work. It's doing these dealing with, tax certificates that had not redeemed. And what do you do from there? How do you force redemption or force, recovery of the property? And it just kind of built like that. And probably, I don't know how many quiet titles I mean, it's in the high hundreds of quiet title actions I've handled. And and over the last 20 years or so. So that kind of explains it right there.
Safe to say you have a boatload of experience in this space.
Yes, and I tell people that I'm probably not the quickest learner, but if you dig ditches long enough, you will become a pretty good ditch digger. There are things about ditch digging you learn, and so I don't think I've been the quickest learner, but through experience, I've learned a lot. And fortunately, I hadn't had any huge mistakes along the way, so I've been fortunate in that regard.
Excellent. Well, for those folks watching, let's see if I can get it to. Bill wrote an excellent white paper, and there'll be a couple opportunities throughout this for everybody to go download that. And it does a great job. I did do my homework, Bill. I did actually read it.
Good.
It does a great job explaining what is. You're right. If you go read the statutes, it's extremely complicated. Actually, I'd say more complicated than I think any other state that I've looked into, simply because there's two different processes, right? And that is recent. And so I guess without getting into that quite yet, from your perspective, Will, would you consider Alabama a tax lien state or a tax deed state, or both?
Really, now I think it's both, and I guess it's important to define what you mean by that. I would say a tax deed state is a state where ultimately, from the tax sale process, you get a deed in the property. You're getting an interest in the property, like an ownership type interest,
right? Versus
a lien state where at the auction, what you get is clearly a lien. And so now we have two systems that are being used by counties in Alabama. One is a system that results in a sale of an interest in the land, where it ultimately becomes a deed, and the other one's where you're purely buying a lien against the property.
Got it. So both, the deed side of it, correct me if I'm wrong here, Will, but it's the deed comes with the redemption period, correct?
At the end of the initial redemption period is when you're entitled to get a deed.
Got it. Okay, so it's both. The deed, I guess I would put it in what I call a redeemable deed category, just to separate it from you don't leave the auction with the ownership of the property right then and there. It does come with a redemption period, but it is a deed nonetheless.
And we can work through what actually occurs, which will put more meaning to whether it's deed or lien state as we go along.
Got it. Okay. So before we dig into that, I know the other thing, I'm gonna wait till the end for you to answer it, if that's okay, Will. But the other thing that's got people excited recently is this Supreme Court case. And maybe you can give us just a quick summary of what it was. Maybe not answer where we're at today or a status. We'll give that at the end. But what exactly was that Supreme Court case that got everybody worked up?
Sure. It was a case that came out last summer 2020, and what it was about, you had a tax purchaser who had gotten a deed and was enforcing their rights in the property, which you sue for possession or ejectment. And they got in a dispute with the owner. The owner, I don't know if the owner was trying to redeem or whatever. They got in a dispute though, and the trial judge, determined that the sale was valid and all. But during the trial or the presentation of evidence to the judge, someone testified to the fact that the tax sale did not occur on the front steps of the courthouse. It was in Jefferson County, the largest county in Alabama. And actually Jefferson County has two divisions, which are almost like separate counties. So it was in one of the divisions, the smaller division, the sale occurred. And the testimony was that the sale occurred inside in a courtroom. And so the trial judge didn't think that was significant at all, determined that the sale was valid and was going to, in the order, granted title and possession to the purchaser. But it was appealed, and the Supreme Court really picked up on the fact that the sale did not occur on the front of the steps of the courthouse, and the statute says the sale is to occur at a public outcry on the front steps of the courthouse, or in front of the courthouse. And so the Supreme Court, Alabama Supreme Court, said you've got to be very strict in following the rules and requirements for these tax sales. And I'm sorry, folks, that the the sale did not occur on the front of the courthouse, it occurred inside, and so you didn't follow the strict requirements, the sale's invalid. That's what our Alabama Supreme Court held. Now, importantly, it was not a majority opinion. It was, to get a majority opinion, you have to have 5 of the justices, 5 of the 9, all agree on the same opinion. Mm-hmm. And what you had was you had 4 justices saying what I just said was the right result. Then you had 4 others saying, no, it was sort of a meaningless, mistake or whatever. It didn't really matter. It didn't impact the sale. And then you had 1 justice in the middle who didn't agree with the 4 who said it was an invalid sale. Well, didn't agree with the reasoning, but did agree that the sale was invalid. So it made the law in that case, but technically it's not binding on other courts, but still it had a pretty shocking effect. Everybody's like, oh my gosh, all the tax sales across Alabama over the last many years are void, because I don't know if any of them are actually held out in front of the courthouse. They're all generally held inside, which sort of makes sense. It's cooler inside. They're held starting in March through June, and it get very hot here. And that, you can control the weather, climate inside, but you can't outside. So it makes sense that counties would go inside. And so everybody was sort of like, oh my gosh, all these sales are void. So it's pretty shocking opinion.
Interesting. And they went retroactive. They didn't just say from this day forward, right? They went back.
Well, the court, I'm sorry to interrupt you, but
no problem.
The court opinion itself did not really deal with that. I mean, the sale I think occurred in 2013, but it didn't go as far to say every tax sale is void or anything. It really just said this tax sale is void.
Okay.
The one that was before it.
So what it did is basically give a defense, right, to others that want to fight, tax sales in the future at that point in time. Okay.
Yeah, that's right, Brian. You've got it. That's what it did. It alerted people to this defense that they may not have thought about.
Got it. Okay. Well, we'll dive into. I know a lot's happened since that Supreme Court ruling, but I'm going to save that to the end.
Okay.
And then, but between here and the end, let's dive. I'll take a step back. We'll get back to how sales actually function in Alabama. And after reading your white paper, there's 2 systems, and so let's start with that. Can you kind of describe, what those 2 systems are?
Yes, the system that had been used traditionally in Alabama, I'll call the land sale system, and it's a system where the auction occurs, the sale goes to the highest bidder, assuming that the highest bid at least covers the amount of taxes that were owed, and you're issued a certificate of purchase. No one really knows technically what that interest is. It's not really a lien. It's more of an interest in the property. It gives you the right to possession of the property. There's some limitations on those rights, but it's more than just a lien. And then if the property is not redeemed within 3 years of the sale, that certificate gets turned in and turned into a deed, a tax deed. That's the traditional system. Just a brief overview what that is.
You call that land sale system, correct?
The land sale system, right. And then the other system I'll just call a lien system and lien sale system. And actually the law for that has existed forever, but no county ever thought it was worthwhile to do until some changes or enhancements were made in 2018. And then when that happened, a few counties decided in 2019, we're going to use that new system. The new lien sale system. And the counties, I think it's like by October before the next sale season, have to announce which one they're going with. So I don't know if they have to announce it if they're staying the same, but if they're going to change, they have to make a public announcement. And so it was just a few the first year. The first year of those sales was 2019, a few more in 2020. And then this year, I understand that 24 of our 67 counties have gone to this new system. Under the new system, you're bidding the interest down, the bidders are. And I think it begins at 12% and you bid it down. And surprisingly to me, what I've heard from a couple of counties, at least for the 2019 sale, the first sale, was that almost all the properties bid down to 0%. So the bidders are bidding down the interest that the owner would have to pay back along with paying the taxes to redeem the property. And so if you're the successful bidder, you get a lien on the property for the amount of the taxes that are owed at the time of the sale, plus whatever interest you bid down to. So if it's down to zero interest, you get zero interest. Anyway, and then you can enforce that lien 3 years after the sale. I'll wait if you want to. We can treat these separately, but and I can get into more detail about that lien sale.
Let's continue on lien sales. We'll come back to land sales.
Okay.
But let's just continue down that path with lien sales and explain how how the interest works, the redemption period. Just give us a full overview.
All right. Well, so the lien sales is the newer system, the one that's been used for 2 years now by several counties, and now this year, third year, I think like 24 counties intend to use the lien sale. And typically my experience with any sales would come at the back end, the enforcement end, and it hasn't been 3 years since the first of those sales, so there hasn't been any enforcement as far as I'm concerned. But let me just give you a little bit of the details about the lien sale system. So as we said, it's a bid down system. You're bidding down the interest, and the winning bidder is the one who makes the lowest bid, and they're given a lien on the property that can be redeemed, by the owner or whoever else has an interest by paying back the taxes and the interest rate with interest at the rate bid down to. After the next year, the property gets sold or auctioned again, the lien does. And the person who bought it the existing lien has the option of getting the new lien at the same rate that they purchased it at the first year. And I guess the third year, subsequent years, it's the same. So if you're the holder of the lien and you decide not to accept that option, then it gets out there and auctioned again, and you have new bidders bidding down the interest on the lien that starts in the subsequent year. So the first year of these sales was 2019. If somebody bid 0% interest on the property comes up again in 2020. If they have the option of saying, I'll take it again at 0%, so they'll pay the taxes again, or they don't exercise that option, and then it gets auctioned again. And then the enforcement mechanism comes in at the end of 3 years. Once you've held it for 3 years, and then up to 10 years from the sale, you can file suit to basically foreclose on that lien. And any time up until the completion of that lawsuit, anybody with a right to redeem would have a right to redeem the property at the interest amount that was bid down to. So I've struggled trying to figure out why it makes sense to attend these sales, because you're putting a lot less money in it, and then you're bidding down zero. If everybody's bidding down at 0% interest, it makes it really easy for someone to redeem it. In fact, I would love it if somebody would buy my property at a tax sale and bid down the interest rate to zero. I might let them do it,
Right.
And maybe you or somebody else, there's something not really thinking about. I guess the only explanation's been given to me in terms of why buyers or investors would want to do that is they think that there will be enough properties that they actually get at the end that don't redeem. And then on those, when they go and foreclose them, they have a lot less cost involved in it because they haven't bid up the price. All they have in is the taxes, which are, like a small percentage of what the property should be worth. So they have a lot less money in it, and it gives them a lot more room to operate, a lot more potential for gain if they actually get clear title to the property. So now, as far as the typical people I've worked for, clients who go to the sales and buy dozens and dozens at a time, I don't know if any of those have attended those kind of sales yet. My hunch is it more local people, but I suspect there are people out there doing it, and maybe people that really understand it better than I do, and have done the numbers and all, and think it will make sense to do that. But it just seems to me that if all you have to do is redeem it, it's just to pay the taxes back without interest, people are going to be thanking them for bidding down the interest, and it'll be real easy for them to redeem. But I don't know. I mean, we'll just have to see.
Yeah, get and I've certainly heard that used in Florida, because Florida, although different system, it's bid down to 0.25%.
But then they're built-in percentages in Florida that you get no matter what, I think. Right. Like a penalty may not be the right word, but there's you can bid it down really low, but there's like a 5% that has to be paid on top of that or something.
Correct.
So in Alabama, in my mind, it just doesn't make sense. And in my experience has been, the more equity there is in a property, the bigger the difference between what the property value is and what the amount to redeem is, the more likely somebody's going to come along and redeem it. I mean, if you've got a $100,000 piece of property, and at the time of foreclosing, soon to foreclose, the investor only has $3,000 in it, from paying the taxes, and there's no interest. And if there's $97,000 of equity, even if you can't come up with $3,000, you'll go find somebody who will come in and give you $3,000, even if you happen to give them half the interest in the property.
Right.
So I don't know. Well, it'll be interesting to see how it works out. I'm curious. I'm speaking next week with two of the tax commissioners who were involved with developing this program. I'll be interested, and I'll have to talk to them before we speak next week at the NTLA conference. But I'll be interested to hear more from them about what their experience has been after 2 years.
Yeah, it's interesting. And let me summarize, and correct me if I'm wrong anywhere here, Will. So basically, investors attend the auction, they bid it down. A lot of them are going for zero, right? You win that certificate or that lien. You have then, I'll say, first right of refusal of at least the next 2 years, where you can take that lien. I'll call them subsequent liens, right? Well, you can either buy them or you can say no, and then they'll re-auction. Somebody else will go buy that lien. At 3 years, so it's 3-year redemption period. You can start to foreclose, but you have up to 10 years, right? Does that sound?
Yeah. Right? Yes. I want to double check. Basically, it's 10 years from the sale, or
liens expire and are no longer valid after 10 years.
I suppose that's what that means. That if you have 3 to 10 years to foreclose on it, then presumably at the end of 10 years, if you haven't foreclosed, that lien probably goes away. But I would presume that's what the outcome would be.
Do you happen to know, Will, I know this is all very new, but do you happen to know if it's something you have to be done with the foreclosure within 10 years, or just have to start it within that 10 year?
I would think you would have to start the lawsuit. I'm pretty sure that deadline. So it's the opportunity to sue to foreclose on that lien begins at the 3-year anniversary of the sale, and it extends until the 10-year anniversary of the sale. And I suspect that I could pull the statute up. We want to stop and take a break real quick. I have it up on my screen, but I would think the deadline at 10 years would be to file your lawsuit.
Got it. Interesting.
I wouldn't think you'd have to have it completed. I think it would be that would be the deadline to get your lawsuit filed.
Okay. Now that interest rate, is it it's a simple interest that you're bidding at? So if you went in at 6, it's just 6% calculated monthly or daily, or?
It's my understanding it's simple annual interest. No compounding.
Okay. Calculated monthly, I'm assuming, or is it daily?
Yeah, I think they would probably calculate it up to the probably daily, but okay. There's no compounding. But so if you came in at 3.5 months to redeem it, they would calculate interest for 3.5 months.
Okay.
I think that's how they do it on the other, on the land sales. They do the interest by day, by day.
Okay. And there's no penalty or anything. I'll use that terminology just because I think it's a little clear. Like in Florida, like if you bid it to zero, it's zero, right? So if they redeem it day 2 or day 364, right?
Or day 10,000.
Right.
That's my understanding. Yeah.
Interesting. Okay. All right. And then I guess for that redemption period, whether you start foreclosure at 3 years or you wait, that whole time period in between, is there anything else required by the investor? Is there any sort of notification required, or you just sit back and wait?
You just sit back and wait. I guess if you were, like after 2 years paying taxes, you're like, wait a minute, why did I invest in something I get 0% interest in? Hey, I really would like to get out of this. You may go contact the owner and say, hey, why don't you go redeem the property so I can get my money out, possibly. But there's no notice required until you get ready to file your lawsuit. And let me just kind of clarify something. It's not, and you didn't say this, but I just want to clarify. it's not a 3-year redemption period. The redemption right lasts up until you complete that foreclosure lawsuit. Right. It's just that the purchaser cannot bring the lawsuit to foreclose until 3 years.
Got it.
So it's really, it's a minimum of 3 years, but extends on until the point that the investor forecloses on the lien.
Okay.
That makes sense.
Yep. Yeah, that makes total sense. I guess, can you describe a little bit about how that foreclosure process works? I waited my 3 years. I want to start foreclosure. What happens at that point?
You've got to give notice to all interested parties and owner or lien holders, and put them on notice that you've got to give 30-day notice that you have an interest in the property, and I guess identify what your interests are before you can bring the lawsuit. And then you would file a lawsuit, and you'd have to name all those interested parties, which would be the owner and any mortgages and lien holders. And they have a right to redeem all the way up to the end of that lawsuit. If you succeed, if as a result of that notice and lawsuit, the people with the right to redeem do not exercise the right to redeem, the court will direct the county to issue a deed to the investor, to the purchaser.
Okay, so it's does the interest rate change at all once you file for foreclosure? Is it still zero or whatever you get?
It's not in the statute. Once that interest rate's set, it's set.
Okay. And that filing of notice, right? Is it safe to call it a notice of intent to foreclose? Is that a correct terminology?
I don't know. I don't have the statute pulled up. I don't know if the notice you have to say that you're about to sue, or if it's simply notice that I bought the lien on this property and I have a lien on the property. Okay. I don't know. I don't know if it specifically requires I'm about to sue you, or if it's simply I have a lien on the property. I want you to know this. I'm not sure.
Got it. But either way, that notice or that point in time is really when an investor would engage an attorney, really, at that point, someone like yourself.
Yeah, well, I would suspect I would encourage investors to maybe consult a lawyer, me or somebody, about the notice that they give. And since I haven't told you exactly what's in it, they could go look in the statute, but and maybe they don't need to consult the lawyer because it may be pretty straightforward. But do your own noticing, because it just doesn't make sense to spend money having a lawyer do it when you may not be able to recover that money if there is a redemption. Probably not going to be able to. So it's in the investor's best interest to do as much of this as they can on their own. There's just not a lot of leverage for recovering any sort of extra expenses on these lien foreclosures.
So at what point in that process would you recommend investors do get attorneys involved?
You're going to have to hire an attorney to file the lawsuit.
Okay.
And that's probably, it probably have good advice. Maybe, you get to the end of 3 years and you've got a bunch of liens, then maybe call a lawyer and say, here's what I have. I just want to make sure I'm handling this right. I'm going to give notice, and then I'm going to file a lawsuit. And, if the lawyer looks at the statute or has some familiarity with it, they say, yeah, that's what you need to do. And then the investors can do that on their own, the noticing. And then, but when they file a lawsuit, they're going to have to hire a lawyer to do that.
Got it. Okay. Now,
unless individuals in Alabama can file suits for themselves, but if you're any kind of organization, you have to have a lawyer represent you in the lawsuit.
Got it.
I don't know if that makes sense or not what I'm saying, but
it does.
If I held a lien in my personal name, I can, and say I'm not a lawyer, I could file the lawsuit in my own name. You can represent yourself like that, but a non-lawyer can't represent anyone else. And if you've got a company, so let's say I have Hereford LLC that owns the property, that Hereford LLC has to have a lawyer file the lawsuit for them. They can't have a non-lawyer file the lawsuit.
Got it. Okay. Yeah, that makes sense. As far as that foreclosure process, is it basically the same as a mortgage foreclosure or any other foreclosure? It's a noticing of interested parties, giving them a preset amount of time to respond, or or not respond, I guess. And depending on what they do, kind of you move on to the next step. And then if nobody responds or everyone says, that's fine, I don't care. At the end of the day, you basically file a application for a deed, and you get a deed at the end of the day. Is that how that works?
That's pretty much it. You would file a lawsuit, and in the lawsuit you would, state that you bought the lien 3 years earlier, or however many years earlier, and that you have a right to ask the court to foreclose on that lien, eliminate all interest of the other parties who have an interest in the property, and requesting the court to issue a deed at the conclusion of the lawsuit pursuant to what the statute says, the statute dealing with these kind of sales. And so if there's not any opposition, if you notify everybody, get them served, and they don't respond to you, then you apply for a default, entry of default, and then a default judgment. And you would be asking the court to enter an order establishing that all these people that you've identified in your complaint no longer have an interest in the property, that all the title that they had in the property or any title in the property has now gone to the plaintiff in the lawsuit, or the purchaser or the investor, the person who brought the lawsuit, now has all title. And the order should direct the clerk to issue a deed to the purchaser at the completion of that lawsuit. All right, so that was how it will operate if there's no response. If somebody responded, if one of the persons named in the lawsuit, one of the defendants responded, they may respond, say, I want to redeem. And then it's a matter of calculating the redemption amount and them coming up with the money to redeem, and either doing that with the plaintiff, the purchaser, working it out together and then telling the court we've resolved it and dismissing the lawsuit, or, it may require the court to enter an order of redemption. And so that's an outcome that could happen. And then that would result in the purchaser getting their money back, plus whatever interest they would be entitled to based on the interest rate that they bid down to.
Got it.
And another option, I guess, would be somebody sued, says, oh, the whole lien sale was invalid. I don't know, raising some other kind of defenses. But typically it comes down to, are you going to redeem or not redeem?
Got it. Now, is that foreclosure process basically eliminates all other interested parties, a mortgage, mechanics lien, those all basically would get wiped out if there's no response or no contesting the foreclosure process?
Yes, the process, this foreclosure process, would wipe out anybody that you've identified in your lawsuit, and you've identified in the complaint that you've actually served. Mm-hmm. So if there's another lien out there that you did not name in the lawsuit, they're unaffected by what happens in that lawsuit. Mm-hmm. But as to anybody named in the lawsuit, if you end up getting a judgment, you've wiped them out. Now, generally, so ad valorem tax liens in Alabama are given the highest priority. They have priority over mortgages. They have priority over IRS liens. There are a type of sort of a subset of liens that it's not so clear, and it's kind of sticky about who has priority. And those are liens that arise from the property use, or liens that relate to like municipal
violations, that sort of thing.
Oh yes, things like that. Okay. Homeowner association liens.
Okay.
It's a little dicey there. It's not exactly clear. It's more complicated than I probably want to try to describe right here. Okay. But some of those, it's kind of a little tricky, and I've never foreclosed on a lien under the lien sale system yet, because we haven't had enough time for any of those to reach 3 years. The first sale occurred in 2019. But in the land sale lawsuits that I filed, if we have certain types of liens, we'll just have to look at them. And sometimes it's easier just to pay them than to argue about who comes first.
Right.
But mortgages, IRS liens, Alabama's Department of Revenue liens, they all get wiped out.
Interesting.
By the sale process.
If
you do the proper noticing.
And I'd say that's pretty unique to Alabama. I'm sure there's other states out there similarly, but most states and most attorneys in those states that I've talked to, IRS liens are one of the few that stick. and you're saying Alabama is one of that is opposite, right? You can actually.
I've come up with across IRS liens dozens of times, and I've only had a lot of times the IRS doesn't respond. A few times they do. I've had one time where an IRS attorney challenged our priority that we had the ability to wipe them out, and my client ended up settling with them. It was more for convenience, but there's a very strong argument. You have to dig pretty deep into like IRS regs and stuff that if a tax lien like a mortgage has priority over an IRS lien, well, it would have, well, put it another way. If the tax lien has priority over a lien that would have priority over an IRS lien, like a mortgage that's already there. No, I'm sorry. We have to clear this up. Let me start over. If the tax sale lien or lien for taxes, ad valorem taxes, has priority over like mortgages, then it would also have priority over the IRS lien.
Okay.
There's authority to say that, but it's real critical though with any IRS lien that you have to give the proper notice to cut it off. And if you don't, then your interest acquired through the tax sale will not impact the IRS lien.
Got it. This is like any other lien. If you don't notify it correctly, then you're not foreclosing.
Yeah, and just to summarize that, because I pretty got a little deep in the weeds there, but on the most, I think the better law is that these ad valorem tax liens have priority over IRS liens.
Got it.
And in dozens of cases I've had involving IRS liens, there's only been one time where the IRS attorney didn't accept my explanation and my memorandum saying why the ad valorem tax lien has priority. And, it was one of those things where you're going to litigate that forever or you're going to resolve it. Again, I think the way better argument is that the ad valorem tax lien has the ability to wipe out the IRS lien.
Got it. Now, as far as timeline goes, I know, and I realize, Will, none of this has been done yet, so maybe it's one of those we don't know. But timeline-wise, how long would that foreclosure typically take if nobody contested it? Is that a 3-month process, 6-month process, 18-month process?
Well, once you file the lawsuit, the next sort of delay period or time period is getting everybody served. And let's say you get everybody served within 30 days, then anybody served the complaint has another 30 days to answer. And if they don't answer, you can apply for your default right then. And typically judges, in the past, judges would just almost automatically grant that default. A lot of them more recently have said, I want to have a hearing about this. I want to know more about what's going on. But they usually don't delay it that often. So you can, like I said, getting people served is sort of the variable about the time. Once that's done, if they don't answer, you can apply for default in 30 days. And typically the judges will respond to that pretty quickly.
Interesting. So it's, I'll say uncontested, that foreclosure would take at least 3 months, let's say. Maybe
probably 3 months is sort of a minimum.
Okay. And longer if it is contested, or if serving takes longer, if you have a lot of people, or you find out,
right,
maybe you serve the wrong one, or they tell you, no, Joe Schmo passed away, here's his heirs. You get to unravel that onion as you go. I understand.
Right.
But really a minimum of at least 3 months. Now, at the end of the day, the deed that you get at the end of the day, having gone through that foreclosure, is that deed, is it insurable, or do you still require a quiet title process to go through to get insurable title, or has that even been tested yet?
Well, you said earlier, you're correct. We haven't been long enough to enforce the first one of those lien sales. So I would think, in contrast to the land sales quiet title process, which we'll get to, where it's more questionable about whether you get insurable title, I would think with these lien sales, once you've gone through that process and you've notified everybody, and if you get a judgment against them and then you get a deed as a result, to me, that ought to be a good title that an insurance company would insure. but we won't know until we go through the process, because the title companies get to decide what they insure or not. I'll tell people that it doesn't really matter what the law is. The title companies get to decide whether they want to insure it or not. Right. And they're going to have to take a look at it and say, are we satisfied that all the due process needed has been done, that there won't be any further challenges? And there will be a lot of questions. In my opinion, though, the purpose of the process identified by the statute for foreclosing and resulting in a deed should be to put the purchaser in a clear title situation with respect to everybody named in the lawsuit, and that title should be insurable. But we won't know until we go through the process and see what the title companies say.
Got it. Yeah, it's like you said, it doesn't matter what the statute or UI think. Rubber will meet the road when the title company gets the first one, and they get to tell you, "This is all right."
That's right. That's right.
We'll issue title insurance, or nope, you got to go do X, Y, Z in order to get title insurance.
Yeah,
they hold the steering wheel there. Okay, well, we've covered the lien sales in pretty good detail. Let's go back to the land sales. It kind of, let's start at the beginning again. How does that sale occur? What does the redemption period look like? How does that process work?
Well, before we move on, if I could ask you a question, like you have more familiarity with the sales in other states than I do, because you're doing these programs, which is trying to keep up with it. I'm sure it's really challenging in all different states. But what do you see the incentive for those lien sales being? Do you? I mean, is that, it may not be something you've had to deal with, but maybe you've talked with people that deal with lien sales, or somebody may have even said, here's why we like bid down lien sales or something like that. I don't know.
Well, I can really only think of two things of why it's being bid down to zero. One is, as you stated, there's a play on the real estate, and they're betting the fact that, okay, I won't earn anything, but at the end of the day, after 3 years and let's say 3 years and 3 months or 3.5 years, I end up with a very small percentage of those properties, and I'm going to make a pretty good return on those properties. And their model says, okay, at the end of the day, granted it's a long wait, at the end of the day, I do pretty well. That's okay. One option. The other option, and I've seen this as well, is a misunderstanding of those statutes, right? It's if I bid it down to zero, or I bid it down to whatever, I'm going to make an automatic maximum percentage on that subsequent. I'll use New Jersey as an example. Bidding down to zero is quite common in New Jersey. They actually have a bid up of premium after not only getting zero, you're bidding premium on top of that. That's money you're not going to get back.
Wow.
But when that next subsequent lien comes around, you make an automatic 18%. It doesn't go at the same rate that you bought the initial lien. It goes at the statute maximum.
Right.
And so it could be a misunderstanding of that statute. I don't know. I guess I don't know who's bidding or why.
Okay. Yeah.
The two reasons that come to my mind of why somebody would bid to zero would be one of those two reasons. And otherwise, I don't know of any other reason.
Well, the way I read the statute, and I haven't, probably should look at it more closely, but that, it's each subsequent year gets bid on. So I don't think that option that you described in New Jersey would apply in Alabama the way I'm reading the Alabama statute, that, hey, I buy it at 0% this year, but next year it'll be 12%. I think you risk, you put it out there to be bid again. So anyway, well, that's interesting. I mean, you kind of, what you've identified would be the reasons I would think of too, either not understanding what you're doing at the sale, or having a model where you think if you buy enough of them, there'll be a certain percentage of them that you'll actually get. And the cushion is so great on those that will make money from that. So,
right.
So sorry to stop you. I just want to hear your thoughts.
No, it's interesting. Not many people ask me questions in reverse. So I appreciate it. It makes it a little more interactive. And I guess I should throw out there, I'm not an attorney. So certainly don't take what I say as being advice.
Well, that was not a legal issue. That was an investment issue. So anyway. Watch out. Some more questions for you coming back at.
Exactly. Bring them on. I'll answer them if I can.
All
right. So let's put the lien sales to the side. We'll come back to the land sales. And I know that's a very different process. So can you just describe that from the beginning, how that works, what the redemption period looks like, and everything involved?
Yeah. So the land sale, the properties that are tax delinquent are auctioned. And they're auctioned off to the highest bidder, with the minimum bid being the amount of taxes that are owed. And typically what happens is, let's say like Jefferson County, a large county, and I don't know if the number is exactly right. Let's say there are 3,000 properties auctioned. You know, there will be a certain percentage of those properties that are, I think the investors would consider kind of high quality properties. I don't know what dollar amount they put on it, but you know, ones they perceive to have greater value, higher likelihood of redeeming. Then you have, and then that will, you know, where that group ends, I don't know. And then you get down to a point of properties that it's hard to justify bidding on them for anything. And so these numbers may be off, but I think like at a typical sale in Jefferson County, there may be like a third of the properties offered for sale that would actually get bids that are equal to the taxes or more than that. And the other ones don't get bid on. They are deemed to be sold to the state of Alabama, and they actually are put on a list that the Alabama Department of Revenue has, as if and technically the state owns those properties. All right. So the ones that are auctioned on that have private bidders, of course, the better properties are usually going to be bid up. And the incentive for bidding it up is that when it's redeemed, you don't only have to pay interest on the taxes, but you also have to pay interest on that overbid up to a certain amount. And so, you know, the better properties are typically overbid. So you may have a property that's worth 100,000 and the taxes are 1,000, and it may get bid to 21,000, for instance. All right, so that's how the sale occurs, and the winning bidders are issued a certificate of purchase following that, and they become the new assessed owners of the properties. So subsequent taxes that the purchaser would pay, they now get bundled into the amount that has to be paid back plus interest. So you know, if you're a buyer and you're convinced that the value of the property is there, you're going to keep paying those taxes until it gets redeemed, or, you know, well, you're either do that or until you in effect foreclose on your interest.
Now, real quick on that, using that example where, let's say the taxes were 3,000, it goes bid up to 21,000. I know because some states are different. Does the bidder have to pay that full 21,000 that day, or do they only pay the 3,000 and the other 18 due on foreclosure, or how does that work? No,
they pay the full 21,000. And to keep the example simple, let's say the taxes were $1,000.
Okay.
So the surplus amount's 20,000.
Right.
You have to pay the full 21,000. So the county would receive the 21,000. They take the $1,000 that's taxes and put that into the tax payment stream where it goes out to all the, you know, the taxing authorities, the cities and school boards and all. And then they just hold the 20,000 separately in a fiduciary account.
Okay.
And we can get into how that's used ultimately in the redemption process, but it's basically sits there to be used for redemption.
Okay. So to redeem, you don't have to redeem the full 21,000. You just have to bring the 1,000 plus interest and so forth. Do I understand?
Yes. Okay. Let me tease that out a little bit. First of all, the interest rate now that is paid is 8%, effective starting last year. It used to be 12%, but they reduced it to 8%. And that's whatever amount is entitled to recover interest on is 8%. Now, I mentioned that you get interest on the surplus or the excess or overbid amount. It's called different things, but you only get it on the portion of the excess that is 15% or less of the value of the property sold. So let me go back to the example. Let's say the property is worth 100,000, the taxes are 1,000, and the winning bid's 21,000. So the $1,000 gets interest. Of the 20, 15% of the value of the $100,000 is $15,000. So if it's redeemed, you're going to get the investor's going to get, they're going to get the 20,000 back, but they're only going to get interest on 15,000 of that at 8% interest. Does that make sense? So I need to explain that another way, or is that?
No, I think that makes perfect sense. So you said 15% of the value of the property. So if it's a $200,000 assessed value, correct, then it's $30,000 that you'll get interest on that property.
That's correct.
Okay.
And it's not unusual. Well, it certainly wasn't unusual when the interest rate was 12% to bid past that 15% level, because, you know, even if you're putting more money out there that's not getting interest, the 15% that you're getting interest on, you know, the how that gets averaged out or whatever, still ends up being a good rate. You know, it could be, you know, at times I think the bidding has like brought the rate down to like, you know, like 6 or 8% overall on the money purchased, and people thought that's a good rate still.
Right.
So, you know, but they won't go too high because they don't want to have too much money out there that's not getting interest.
Right.
I suspect at 8%, they're probably still bidding over that 15%, because a lot of the people that come to these sales have their own money, very low, you know, money doesn't cost a lot these days. And so, you know, I don't know what percent they'll bid down to, but they'll probably go over that surplus or that 15% cap to, you know, where the effective rate 6%, 5%. I don't know. I don't know what the number is.
So they'll still go above it, maybe not as high as they would go when it was 12, but they'll still go above.
Perhaps.
Right.
Yeah.
Whatever their internal model is or their goal.
That's right.
Right. Okay. Understood. Okay. So they buy, let's go back to that example. They buy that $100,000 property for $21,000. They get the lien. They're going to earn interest on that $15,000. Now what happens after the sale for the next, what is it, 3 years? How long?
3 years. Yeah. So there's the initial 3-year redemption period in Alabama on these land sales, and the owner can redeem at any time during those 3 years. And so no notice is required by the purchaser or anything. You know, the investors, like the people who come in and buy a lot of this, have been doing this. They don't mess with the property at all. You know, they just hope the property, they're doing their due diligence. They want to buy properties they're going to redeem. More local, as a generality, some of the local investors think, wait a minute, I buy this property at the tax sale, I go get possession of it and put a tenant in it, I can collect rent at the same time. If there's going to be a redemption, I'm going to get 12% on my money. And so they may be more aggressive about going and getting the property. But for, I don't know what the people are that listen to your programs and stuff. I don't know. I think in terms primarily of the companies that buy these, because that's who I've represented. Typically, they just leave the property alone. They don't want, you know, they have a point at which they would love for these properties to redeem. I don't know if it's 18 months or, you know, whatever it is, their models show where they get the maximum amount of interest. And that's what they hope will happen. They're not going to stir anybody to redeem, and they just don't really do anything for 3 years. But if there is a redemption, the owner would come down and request a redemption statement from the county. And the statement that the county is going to give them is going to show them the amount of taxes that have been paid, the surplus amount plus 12% interest on those amounts. And then they're going to show the surplus amount as a credit on that statement. So in our example, we have the $20,000 surplus, and let's say it's been 2 years of taxes paid. So you've got $2,000 in taxes, and you have $20,000, which 15 of it is earning interest at 8%. I don't know what the numbers are. Let's just say the total redemption amount would be 22. Let's just say $25,000 at that point. That will be the total, and then they'll show the 20,000 as a credit on that, so the person redeeming it would only have to come up with $5,000 to redeem it.
Got it. Okay.
Does that make sense?
Mm-hmm. So you don't have to come up with the full amount. They have to come up with the tax amount plus whatever interest is due on that tax amount plus that what do we want to call that amount? That 15% that's earning taxes.
Right.
That tax amount as well, or that interest amount as well.
Right. And so then the county will get the 5,000, and then they'll pull the 20,000 from that fiduciary account and cut a $25,000 check that goes back to the purchaser. Okay.
Or the current lien holder, right? If there's a
right.
Okay.
There's an assignment. Yeah. Whoever's holding that certificate now.
Interesting. Okay. So that's the first 3 years, I guess. They gain ownership of that property, right? So are they liable if something happens in that property? Like, where does that ownership? How?
That's very interesting. So what we're talking about right now is the certificate period, or the administrative redemption period. It's the 3 years from the day of the tax sale. there's Alabama case law that says that certificate does not represent title to the property. However, there have been municipalities who are trying to enforce, ordinances or whatever, or maybe homeowner associations are saying, you hold a certificate, you're the owner, you're responsible. So it's not real clear, what sort of responsibility a certificate holder has. Typically, it doesn't come up. It just usually is not an issue. But there have been a number of situations where clients of mine have gotten issued, notices from the court where the city has filed an action to enforce an ordinance, like a weed lien ordinance or something, or they've already gone out and cut the weeds and they have a bill for that, and they are trying to force the purchaser, the certificate holder, to be responsible for it. It doesn't come up very often. When it has come up, a lot of times the certificate holder calls and tells them, look, I don't have control of this property. I've never taken control. The person that owned it when I bought it is still in there. I'll have a certificate. I don't have a deed to the property. A lot of times the city will just, say, okay, we're not going to pursue it. But there have been times when they've taken a hard stance, but it comes up very, very rarely.
So it's a gray area at best.
Yes.
Got it.
I would say though, if you're the certificate holder and you go into possession and assert control over it, that's a different thing. You then probably are have greater responsibility for those charges. You may now have premises liability responsibility. If something happens on the property and your control of it, that's the basis for finding somebody responsible in terms of an accident occurs on property, who owns and controls the property. Right, and actually control is probably a bigger factor than who owns it.
Interesting. So it's so it can kind of depend, if I understand right, Will, it kind of depends on how you treat it, right? So if you're treating it as you have ownership and you go and secure the property and you are taking possession, then they may treat you as the owner, or if you're fairly hands off and you treat it as, hey, I just have a lien on that property, then they may not enforce it as much. But regardless, it's a very gray area. Just know for the viewers out there, just know that it really can vary widely, probably from one county to the next, who the county officials are.
Well, it's not just the county involved. If you go out there and take control of the property and then somebody's injured on it, that's the person you have to be concerned about, not the county. So I would just say in the thousands and thousands of properties I've been involved with, for my clients, I don't recall who never really go into possession of properties unless it's like clearly abandoned and they need to preserve it. So it's fairly rare. No situations ever come up where they've been held responsible, or anybody's attempted to hold them responsible for an injury that occurred on the property. I'm not saying there may not be a basis for claiming that they're responsible, the purchaser. It just hasn't happened.
Okay.
There have been a handful of times where the municipalities have tried to, assert that they are the owner of the property. And I've had a number of situations where homeowners associations saying to the certificate holder, you got to pay these dues, but that's fairly rare overall as well.
Got it. Okay. All right. So that kind of covers the first 3 years you mentioned. So what happens at the end of that first 3 years?
So at the end of the 3 years, the process of redeeming through the county is gone. You can't go to the county and say, I want to redeem it. And let me clarify something. We're talking about the properties that get sold at the auction to bidders.
Right.
There's a whole different category that we're not talking about, properties that did not get bid on at the sale that go to the state of Alabama. Okay.
Well,
so I'm not talking about those. I'll call those sold to state properties. We're not talking about those. But at the end of 3 years, the purchaser is entitled to apply for a deed. And there is Alabama case law that says that deed constitutes legal title. But through years of case law and also statutory changes, that title in the property is subject to really a couple of claims that the former owner or other interest holders would have. And that is a right to redeem still, and a right to challenge the validity of the sale. So if you're the if you are the purchaser, it's been more than 3 years, you get your deed. Actually, you could probably move forward and enforce your rights without a deed, but I think it's better to have a deed. Everybody sort of understands what a deed is, and you've got your deed. Your goal now is to, if you either want to force the owner to or mortgage holder to redeem, or you want to establish your title and right to possession of the property, so then you can get out of, whatever equity is out of the property on a sale of the property. Okay, so your goal is, if there's not going to be redemption, how do I cut off these rights that the former owner and mortgagees have, so that a title company will be okay with my title and insure my title? That's what you have ahead of you if you're the purchaser.
Right.
And so there are a number of ways to do that. I mean, the owner or anybody else with an interest can redeem or assert this right to challenge the validity of the sale up to the point where the purchaser has cut off that right.
Okay.
Kind of sounds kind of funny the way I explain it, but it's like, how long does the right last? Well, it lasts as long until the purchaser cuts it off. Okay, so what does it take to cut off the right is the real question. How do you cut off this right to redeem, to challenge the validity of the sale? And so there's a misunderstanding for a lot of purchasers, particularly I would say the more local purchasers, that once I get that deed, that property's mine. You don't have any redemption rights, owner, but that's not true. There's a continuing right to redeem. You have to cut off those rights. So one of the ways it's recognized to cut off the right to redeem and challenge the validity of the sale is for the purchaser to get possession of the property and be in possession of the property for 3 years. In other words, establish adverse possession for 3 years. That will cut off those challenges. It cuts off the right to redeem. It cuts off any challenge to the validity of the sale. But a title company is not going to accept an affidavit from the purchaser, I've been in adverse possession for 3 years. If you've been in adverse possession for 3 years, you may have a defense. You don't have to go further to get clear, to clear up the title, whatever. But you could be fairly confident at that point that you can defend any challenge to your title after you've got a deed and been in possession for 3 years, and you've given lien holders notice. Okay. But if you want to get title insurance, you're probably still going to have to file a quiet title action to have a court order conclude that, yes, you have a deed and you've been in adverse possession for 3 years, and all these people that had an interest in the property that would have had a right to redeem or would have had a right to challenge the sale, their time has been eliminated, or their opportunity to do that's been eliminated by your adverse possession. So that's one way to cut off the right to redeem, and that's a pretty time-consuming process. You've got to go get possession, which can be tricky and can, result in some conflicts, but let's say, the people are still living there. You can't just go run them out.
Right.
You may have to sue them to get possession and then wait another 3 years to get to sue to quiet title under that approach.
Got it.
That's one way.
Okay, you can't start the quiet title till after you've had possession for 3 years, and if you do nothing to get possession for 2 years, you got to wait 3 more years. So the clock starts once you have possession. You wait 3 years, then you can file a quiet title. So that's one option. What are the other options?
All right, another option would be you go to all the people who have an interest in the property, and they agree to release or quitclaim to deed their interest to you. So you basically, let's say, it's John Smith's property. You go to him and say, John, if you're not going to redeem this property from me, I'm going to have to sue you for possession. And why don't you just deed the property to me? Now, that's one way of doing it. I don't ever see that happen. Nobody just gives up their rights that easily. You normally have to sue them. But that would be one way. Right. Sort of a voluntary way.
Okay.
All right, and then just backtrack a little bit. So I said that, the right to redeem or challenge a sale lasts up until the point those rights are cut off. Right. So anytime before the 3 years adverse possession or you ask for a deed from the former owner, they give it to you, they still have a right to redeem or to challenge the validity of the sale.
Got it.
All right, so that's method 2. First method is you get possession, you maintain adverse possession for 3 years, and then you file suit to quiet title. Method 2 is you somehow get the former owners and people with an interest in it to deed you their interest or release their interest to you, which you may get it from one party or something, but usually the main owner is not going to be willing to just voluntarily do that. The third way, and this is an approach that I take, and it's somewhat, I wouldn't say it's controversial, but it's hard to get people to agree with me, other than I occasionally can work with title companies that say, yeah, I understand what you're doing, Will, is to file a suit to establish possession of the property, which is known as an ejectment lawsuit.
Okay.
And an ejectment is like the complementary action to a quiet title. A quiet title action is, I'm in possession of the property. I have peaceable possession. Nobody's challenging my possession. I have a title to the property, and you should go ahead and give me clear title to the property. Ejectment is, I'm not in possession. Somebody else is in possession or claims possession, but I have title to the property. I'm entitled to possession, so I'm going to sue them. In either case, one of the critical issues in the lawsuit is the validity of the title of the plaintiff, of the tax holder, so tax deed holder. So in a quiet title, you're saying, I have title. I'm in possession. Nobody's challenging my possession. With an ejectment is, I have title. I have legal title based on the tax deed. I have a right to possession of the property, and I don't have possession of the property. So I want to sue anybody who has a claim for possession. So my lawsuits are, so this is good. I'm not going to give way too deep in the weeds, but effectively, even if people aren't in possession of the property, like owners or mortgagees, their right to redeem based on sort of a fictional possession of property where no one's in possession. So the courts say, if no one's in possession of the property, then the former owner is deemed to be in possession of the property still. So my theory is, even if the former owner is not in possession, I still have to sue them for possession, because under the law, they're deemed to have possession for purposes of redeeming it. So when I bring my lawsuit, it's basically asserting a right for declaratory judgment, asking the court to determine the sale is valid and determine the rights of the party. Then I bring an action for ejectment, which says I have legal title of the property, and I want you, court, to confirm my legal title, and I want you to order my right to possession and dispossess these people I've sued. And then I say, and if nobody's challenging my possession, then give me quiet title. If I assert this claim and nobody says, no, I'm in possession, well, then I should be able to claim that I'm in at least constructive possession as the holder of a tax deed, and you can be in constructive possession. And if nobody challenges that, then that's peaceable, and go ahead and order quiet title relief. Well, most of the times there is somebody in the property, and if they don't redeem during the lawsuit as a result of me suing them, and I get an order for ejectment, that establishes my title and right to possession of the property. And my argument is that cuts off any rights that the former owner would have to redeem at that point. I don't have to get that order establishing my title and then maintain possession for 3 more years to cut off the right to redeem. If the owner or whoever I sued wanted to assert a right to redeem or challenge the sale, that was a compulsory counterclaim that they would need to bring in that lawsuit. And if they don't bring it up, I've wiped them out then. Now, I don't know if other people have adopted that argument or that position I've just taken. I've written an article about it, a law review article explaining why I think that's a correct position. No one's been able to, whenever you write an article about something like that, you're always thinking somebody's going to come along and say, some obvious thing you screwed up on or missed.
Yeah.
That hasn't happened. And I think it's a pretty sound argument. And, right now there's one title company at least out there that agrees with me. And so when we complete that process, they will insure the title following that process.
So is that ejectment something you have? So it sounds like you don't have to wait the 3 years. You don't have to get possession. You just start that. I'll say the additional 3 years. You start that as soon as you get that deed. After the first 3 years, you start that ejectment case right then and there. And at the end of that,
you can if you want to. Yeah,
okay.
You can start it right then.
And that at the end of that case, at least one title company has said, okay, you have insurable title, right? So because you're quieting it at the same time.
Yes, technically you're not. To me, if you get an order of ejectment, the court's saying you, the purchaser who brought this lawsuit, you have good title, and I'm putting you in possession of the property. It's, you know, I will try to put in quiet title language in the orders. Typically, judges don't pick up on it one way or another, but technically it's not a quiet title order. It's more of a order of ejectment, but it does sort of the same thing with respect to title, determining who has a valid title, and it puts you in possession of the property. And to me, that's what eliminates any challenges to
the whole key is you don't have to do a whole separate quiet title process to get title insurance after the ejectment.
Yes. Now, so
that title
for years,
you're good.
I told you, I kind of got started this 1999, 2000, probably about 5 or 6 years. I would file suit for possession, get possession, and then 3 years later bring a quiet title action. And in doing that, I'm like, this is ridiculous. I've already sued these people to get possession. Now they're scattered 3 years later, and they may have died and may have heirs. This is making it so much more complicated to clear title. I can't even find these people. You know, before they were at the house, but now they're nowhere around. They don't want to be sued again.
Right.
And I just thought this doesn't make any sense. And so a lawyer in my firm helped me research it, and we researched it, and we kind of came to the conclusion, you know what? We should be able to do this in one lawsuit.
Interesting.
Now, I don't think you'll find anything in writing out there. There have been law review articles written about it, other articles in Alabama legal magazines, a lot of title companies writing about this. I don't think you'll find anybody that has made the case that I make. They all think you've got to do these 2-3 year, you've got to get possession, be in possession for 3 years. So if you can't bring your lawsuit and expect to get a clear title that wipes out the interest. You got to get possession and wait 3 years. That's what everybody sort of thinks you have to do. I don't think you have to. And I've been successful doing it the way I'm doing it.
Interesting. Now, how long does an ejectment typically take?
Now that just varies. Like the best case scenario would be like the other lawsuit we talked about in the lien sale.
Right.
If you can name everybody and serve them pretty quickly, and they don't respond, you can get it done in 3 months, possibly.
Got it.
But if there are objections and whatever, it can go on a very long time. I think, 1 year I filed like, 30 lawsuits all about the same week, within a week. And, some of those got resolved within 3 months, some 6. I think the longest were almost all of them were completed in 18 months, and some took a little longer. But, usually it's not typically the court that holds it up. It's more typically the defendants raising issues and stuff, or maybe strategically you don't want to push too fast. You're trying to give them an opportunity to redeem the property, and you give them more time, those kind of things. But, I'd say best case scenario, 3 months, maybe typical 8 to 12 months, something like that, or a little longer, depending on the circumstances.
Got it. Interesting. Okay. So, just to kind of recap there's 3 options you can do at the end of the 3 years. One is you get possession, keep it for 3 years, file quiet title. That'll get you insurable title. The other one is you can go back to all the previous interested parties, get their interest signed over, right? I'm assuming like quick claim deed signed, typically
right,
probably paying them for it, and clear it that way. And the third one is this ejectment process, which you can start right away. You don't have to wait 3 years. And so far you have at least one title company that'll issue title insurance from it, and there's been no challenges to that ejectment.
The title companies that have worked with me over the years have changed. There'll be one that says, yeah, I agree with you. And then somebody comes along and somebody else there at the company is looking at like, no, we don't do this. And so I have to go find somebody else. But I've cleared title to probably 500 or more properties. I mean, I've handled a lot more than that, but a lot of times you're forcing a redemption, but there are hundreds of them. And there's never been anybody come back afterwards and say, you didn't, that asserted a right to redeem or to challenge the sale. It just never happens. And it wouldn't really make sense to happen, because you gotta set aside a judgment. Like, wait, you were served in this lawsuit. You never raised that in that lawsuit. You're barred from raising that right now. That would be one argument you would have. So, even though I understand the case law out there that concerns title companies generally, as a practical matter, it would be a very rare circumstance where it would make sense for somebody who's been sued and has a judgment against them to challenge the judgment against them. And really all I can think of is, let's say, you all of a sudden somebody learns that there's gold underneath the dirt there, or oil, and now the property's worth a lot more. Maybe it's worth going back and fighting, but normally it's not going to be worth fighting, because if you win, you're going to have to pay back all this stuff anyway.
Right. Interesting. Now, throughout that whole process, obviously there's attorney fees involved. Are those attorney fees something that is redeemable or reimbursable as part of that redemption, or are those just expenses on the part of the? Yes.
Before I get to that, because there's an aspect that I hadn't talked about to sort of make things a little simpler, okay. But the lien holders on the property do not get notice of the tax sale at the time of the tax sale. So one of the things as a purchaser you have to do in addition to whatever you'd have to do to cut off the rights of the owner to redeem, is you have to give written notice to the lien holders.
Okay.
And then those lien holders have whatever rights to redeem the owner has, plus they have a right to redeem for 1 year following that written notice. So it may be that you get the tax deed, and you were right, you could go ahead and file suit, but there's some lien holders out there, and you may decide, what I'm going to do, I'm going to send them written notice and wait a year before I then bring my lawsuit, because I don't want to be in the middle of the lawsuit and the mortgagee say, hey, I still within my 1 year right to redeem, from the time you gave me notice, and that I want to operate under that redemption right, which has certain advantages against the purchaser.
Can you send that notice during that first 3 year period, or do you have to
you could typically they just and in fact early on, which was a while back when we were talking, I'll tell you how I got into this. That's what we recommended to that first client I have, is send your notices out before the deed, you get a deed, so they will have expired when you get the deed. But what one company did that I didn't represent, I don't think they were represented, but those notices they sent out were a little bit misleading, and they ended up getting sued in a class action lawsuit. So, you gotta be careful. But the clients I've represented, they just typically don't even send the notice out. Typically what they do is they wait till they can get a deed, then they order title work, because any of these expenses that you incur during that first 3 year period, you're not going to recoup. Expenses like title work and all.
Right.
So they just wait, let's say they buy 100 properties, they're counting on 95 of those properties redeeming. Why do any effort on any of them if most of them are going to redeem? And so the properties they have now after 3 years, let's say it's 5, then they'll get the title work, then they'll send out notice. And sometimes I'll recommend waiting a year until after those notices are sent to the lien holder. Sometimes I'll say, they're not going to redeem, let's just get going. Let's just go sue them. It just kind of depends on the situation. But if you're going to be safe and give yourself the most leverage as the purchaser when you file that lawsuit, you would want those 1 year notices to have expired.
Got it. Now, you mentioned, I guess back to the fee question, you mentioned it does not get reimbursed in that first 3 years. After that 3 years, it does or don't? What
exactly? What
are the attorney fees?
Okay, so here, so all right. The right to redeem following the 3 years that an owner has is a right to redeem that can be exercised in a lawsuit. Either the owner or lien holder filing suit to redeem, or the purchaser filing suit for possession, and in response, the owner counterclaiming to redeem.
Right.
That's technically the right to redeem after the first year. So they call it judicial redemption because the right exists within the context of a lawsuit being filed. Before that lawsuit's filed, if there's parties are trying to work something out, you're basically just negotiating a settlement at that point.
Mm-hmm.
In other words, let's say my client has a deed to the property, but they haven't filed suit, and we've notified everybody, and somebody comes along and says, we want to redeem. And we, technically the client could say, let's say the redemption amount would be $25,000. The client said, okay, give me $40,000. And the owner would say, well, why would I do that? And the purchaser could say, well, you don't have to, but I don't have to voluntarily deed this property back to you either, So basically the owner's option at that point is like, I'm going to sue you then. But anyway, when you're not in a lawsuit, you're basically negotiating. And so a lot of times what leads to the discussion is that the tax purchaser's hired an attorney and they've sent notices or whatever, and they've done title work and they've incurred $1,000 or $2,000 worth of fees and expenses. And the owner comes to them and says, we want to redeem. And what kind of moves it along faster is just for the purchaser to say, okay, I'm not calling this a redemption. We're just going to call this a settlement. Here's how much I will take, and I'll give you the numbers. The numbers are what a redemption amount is, plus I have these extra $2,000 expenses. If you'll pay that, I'll deed the property to you. And the owner may say, I don't have to pay you for those attorney's fees. And the purchaser can say, you're right, you don't have to pay me anything. You don't have to. So then the owner's option is to sue. And so typically, particularly if the owner's represented by an attorney themselves, the attorney will say, look, they can't require you to pay anything right now. All the purchaser has is a deed. You don't owe them anything. You have a redemption right. You can exercise your redemption right, but you're going to have to file a lawsuit. And so to pay the purchaser what would be a redemption amount plus the $2,000 in expenses for attorney's fees and title work, that's probably the best thing you can do, rather than paying me $2,000 or $3,000 to file your lawsuit to redeem it.
Right. You're paying somebody, right? So
right.
Pay your attorney or pay the other attorney. And
so you're not, when you have that deed, you're not entitled to these fees and expenses, but you have some leverage to ask that they be paid.
Got it.
If the owner files suit first to redeem, then they can get a court to order redemption for an amount that does not include attorney's fees and title work, those expenses.
Okay.
But if the purchaser files suit first and the owner counterclaims or moves to redeem in that lawsuit, the purchaser can claim and ask the court to include as part of the redemption amount the reasonable cost, including attorney's fees, for bringing that lawsuit.
Okay.
So if the owner files suit first, there's no basis to claim attorney's fees. If the purchaser files suit first, there is a basis to claim them.
Okay.
Doesn't mean you're going to get them all, but you have the ability to say, as the purchaser's attorney, if the owner says, I want to redeem, I would present to the opposing attorney, here's what I say the redemption amount, it includes these attorney's fees. And if they say we don't want to pay that, so well, we can have the judge determine the redemption amount, because that's who's going to ultimately determine if we can't agree on it. And here's the statute says I'm entitled to reasonable attorney's fees. I think these attorney's fees are reasonable, and they're only going to go up if we fight about it. And so you try to work it out, Now,
is there any sort of nuance that those attorney fees or those expenses have to be after that first 3 period, or is it you just don't have any real legs to stand on until after that 3-year period? But if you have any expenses before then, you can add those in.
So the basis for the attorney's fees is the reasonable attorney's fees in bringing the action. So you would have to be able to say what work was done by a lawyer that was necessary for bringing the lawsuit. It would be hard to find, to say that something was done back in the original 3-year certificate period was necessary for bringing the lawsuit, probably. But I've argued that doing the title work, sending out the notices, all that's required to bring the lawsuit. If the purpose of the lawsuit is to establish possession of the property against anybody who has a right to redeem. So I have to go do title work on it, and I have to notify these lien holders. So those are expenses that I think are related to bringing the lawsuit that should be recovered. And in the hundreds and hundreds of cases I've handled, I think the attorney's fees have been litigated maybe a dozen times. Usually you get it worked out, or there's some compromise there or something. But when it's really been contested, I go on the witness stand and attest to the reasonableness of my attorney's fees. And I've actually called the opposing attorney before to cross-examine him to show the reasonableness of my attorney's fees, to get them to explain, do you know how to obtain possession of a property on a tax deed and clear the title? Yeah, I know how to do it. Okay, well, you got to do this, right? Yeah, you got to do this. You got to do this, right? Yes. And so this is what I was doing, and isn't that reasonable to do? And they can't really challenge what we've done. They may say the rate's too high or something, but we don't think we're doing anything unnecessary for bringing the lawsuit.
Interesting. Okay. I think I understand the two systems pretty well. I guess just to kind of recap for everybody, essentially in 2019, there was this new lien sale system that came about, 2019 prior, and still today, it sounds like you said majority, right? Almost 2/3 of the counties still have the land sale system where, you bid up that premium, the 15% of the assessed value earns interest. It can redeem in that first 3 years. If it doesn't, there's a lot of things that can happen, but the whole goal is to get, possession of the property with title insurance. And there's 3 different ways you can do that. The one that seems to work the best, in your opinion, Will, is the ejectment. The other key to kind of take out from that is, as far as attorney fees goes, you have not necessarily a right, but have some negotiating power after that first 3-year period ends. And so kind of limit your expenses in that first 3 years, because if it redeems in that first 3 years, they just go to the county, they pay it, it redeems, you have really no negotiation power. And then on the lien sale side, you bid it down. There's at least a 3-year period you have to wait before you file foreclosure, up to 10 years. And it's a pretty standard foreclosure process, it sounds like. And at the end of that foreclosure process, I guess we'll find out, but it sounds like it should be insurable, and the title companies will tell us when the first one comes about.
Right.
Did I summarize kind of those two processes fairly well?
Yeah, you're a really quick
All
study on.
All right. So, all right. And then I guess I want to kind of revisit something that we touched on in the beginning, and it sounds like there's been some developments in that Supreme Court case. So can you kind of fill us in on what the latest and greatest is there?
Yeah. So as we talked about early on, that case basically said that a tax sale that did not occur in front of the courthouse was void because it didn't strictly follow the requirements required under the statute dealing with tax sales. The losing party, the purchaser, asked the Supreme Court to reconsider. There were lots of briefs that were filed by the County Association, the National Tax Lien Association, I think, filed one, the tax collector, various organizations. They all made very persuasive arguments. I mean, basically the argument was, you can't do this to us. We've had all these sales. You can't invalidate all of our sales. And the Supreme Court said, I'm sorry. Well, there have been two, our legislature in Alabama is in session right now, and there have been 2 bills, one in the Senate, one in the House, that have both been introduced, identical bills, that provide that a sale that occurs on the premises of the courthouse or inside the courthouse is valid. And it provides that if that bill is passed, it would apply to past sales as well.
Okay.
So, there is a legal question about a new law applying retroactively or not. That's can get into a very deep legal issue about whether you can pass a law that now applies backwards in time. But I don't think that will be challenged, but I don't know. So I would expect, I think that one of these bills is going to end up being passed, go through both houses and get signed into law. That's my anticipation. It's an easy sale. It's like, we'll, if you're telling all these legislatures, like, if you don't do this, then we've got thousands and thousands of sales that are potentially invalid, and that's going to mess up these counties. It's kind of easy to make it sound really terrible. So I think one of those bills is going to go through, become the law, and that will probably take care of that lawsuit, that decision, and that opinion.
What does that timeline look like as far as one of those? It's end of February 2021 right now. What is that? How long does that typically take for a law to get through legislation and effective?
I would think so. The session began early February. I would think there've been bills that have already gotten through.
Okay.
I looked today at both of these. The one in the Senate, I think, is further along. It looks like it could be pretty close. I don't know. I think our session ends. I'm not sure when it is, but I've never known one to go past April, really.
Okay.
So I anticipate that it could be pretty soon. I don't think, it could have a major impact on the sales coming up, and it's only going to, any of the sales. So I suspect what the counties will do, if they don't get this law passed before the next sale, they'll have that sale out in front of the courthouse,
right,
to make sure they're complying with the statute, the way it's written right now.
Got it. Is there any other changes or statute changes or otherwise coming down the pipeline that would change how, the process in Alabama works overall?
No, a couple other things I'll mention. There was a decision, I think from 2018, that causes some problems that people need to be aware of. And I think it's a wrongly decided the opinion, but it is out there nonetheless. It's not our highest court, it's our Court of Civil Appeals, but there's not a higher court decision overruling it. But it effectively said, if you're the purchaser at one of these land sales, or if you get a deed from one of these land sales, so you could get your deed through the sale to the state of Alabama, from the point when you're entitled to a deed, if you don't bring suit or establish possession within 3 years of that date, you forfeit your interest in the property.
Huh. Okay.
It takes too long to get into the details of all that. So the main point there is, if you were a purchaser at the auction and you after 3 years you're entitled to a deed, so now you have another 3 years before you either need to be in possession or sue for possession.
Got it.
That's the primary thing.
Clock or timeline.
Right. It's so, it doesn't necessarily expire, but there's case law saying if you don't assert your rights as a purchaser within that time, you lose your interest.
Okay. Understood.
And then if you buy your property from the state, then it's when you're entitled to a deed. And usually, anyway, you need to be aware of that.
Okay.
That concern out there. So you don't want to sleep on it.
Yeah. Don't sleep on it too long. Right.
That's one thing. Another thing that's kind of coming through, and it really won't impact, I think, most of the people listen to this, is there bills been introduced that would increase the number of counties and cities that could have land banks.
Okay.
And land banks are kind of associated with this tax sales, and that they have some advantages for acquiring properties from the state. So we talked about the land sale contract. You have a group of properties that are sold to bidders, and then you have a group that are sold to the state.
Mm-hmm.
And typically the ones sold to the state have the lower value, and some of those have really, really low value. Well, land banks have been created in Alabama. I think there's Birmingham, maybe Mobile, and there are advantages that the land bank have to clearing title that other people don't have. And so they can acquire property from the state for no cost, really, these sold to state properties, and clear the title and utilize those properties, sell them to people or use them for development or whatever. Well, the bill out there right now will increase the number. I think it was before, it was limited to counties or cities of a certain population.
Okay.
They're reducing that population number, so now smaller communities can do land banks also. I don't really think that impacts, like I said, a lot of people listen to this, but it's interesting to me because in doing this for so long, I've kind of gone down these other rabbit holes. And one of them is, what do you do about all these thousands of properties that have very low value, that have messed up tax titles? How do you clear that up? And the idea, I think, with the land bank would be, it provides a better mechanism for clearing up title. I can debate that, whether it does or not, because sometimes a land bank, like any administrative organization, can sometimes make things more difficult. But that's sort of the idea, I think, is let's give other communities the ability to create land banks and go get some of these sold to state properties and clear up the title and get them back on the tax rolls.
So for the viewers that are watching that are a little more interested in acquiring the property as opposed to just the interest or return, then they can check that out in more detail.
That's right. I think that would be more the play, buying properties from the state, as you actually hope to get the property, not, the model wouldn't be based so much on redemption, be more on, I want to get the property. So the article that law review article that I wrote that's footnoted, I think, in the memo that you showed at the beginning of the program, which you can access through our website. That it deals with that issue of this ever-growing number of properties that the state owns.
Got it. And I think maybe we'll have another episode sometime in the future, Will, if you're willing to come back and talk with us and talk more about that state-owned property process. Sounds like there's some nuances there. I'd love to dig into that. But I greatly appreciate your time, Will. One thing I love about this industry, I come from the aerospace industry, but I learn more on a daily basis talking about taxes and property taxes and tax sales than I ever did in the aerospace industry. And I learned a lot today. So appreciate your time. I'm sure everybody watching appreciates your time, and hopefully we can have you back.
Well, Brian, I appreciate you. I am very impressed at how you caught on very quickly and understand sort of the nuances. My clients always tell me it's the most complicated state they deal with, and I assume it is. I don't deal a lot with other states, but my experience is it does seem more complicated than other states, and you picked up on it very quickly. So good job. Good question.
I did my homework, and again, Farrell, there's Will wrote a great white paper here. He has it on his website. We'll actually have a link up here. You can download it here as well. Do your homework. I read it, so I knew some of the answers before I asked them. Loaded questions, I guess. But again, thank you very much, and we'll talk to you soon.
All right. Thank you. Bye-bye.